Sorry everyone to keep you waiting, and welcome to today's Constitution Unit webinar on Ministerial Standards. I'm Robert Hazell, Professor of Government and the Constitution at UCL and previous Director of the Constitution Unit, and I'm chairing today's event. The backdrop is that Westminster and the Scottish Parliament have both been engulfed by scandals over ministerial behaviour in the past year, and in Whitehall there's been a separate scandal over officials' two-timing while still in the civil service, revealed by the Lex Greensill affair. To discuss these issues, we're joined today by three speakers. First, Sir Allan, former senior civil servant, who until last year was the Prime Minister's independent advisor on ministers' interests. Next, to tell us about the different standards regime in Scotland, we have Susan Deacon, who was Minister of Health in Scotland in the first Scottish government post-devolution, and more recently, Chair of the Institute of Directors in Scotland and of the Scottish Police Authority. And our third speaker is Richard Thomas, a lawyer who became the Information Commissioner and is now a member of the Advisory Committee on Business Appointments, the committee which advises ministers and senior officials on potential conflicts of interest when they take up appointments after leaving Whitehall. Each speaker will speak initially for 5 minutes, after which we'll have a panel discussion before opening up to questions from the audience. If you have a question that you'd like to put to the speakers, please write it in the Q&A function as opposed to the chat. Lisa James, our Q&A facilitator, will select questions in groups and ask each questioner to unmute and ask their question directly. If you'd rather not ask your question direct, please indicate when submitting it, and Lisa will ask it on your behalf. So without further ado, let me turn to our first speaker, Sir Allan. Alex, over to you.
Thank you very much, Robert. If I could perhaps start with a little bit of history. I mean, the Ministerial Code is a rather strange document. It originates from a document called Questions of Procedure for Ministers, which was first issued in 1945 under the Attlee government and was then issued under all successive prime ministers. It was first published in 1992 with John Major as Prime Minister, and then was renamed as the Ministerial Code by Tony Blair in 1997 when he took office. And some of the passages in the current Ministerial Code are almost identical to those running back through all the previous iterations. It was originally almost wholly about procedure, and a lot of it still is, but bits about the conduct of ministers have gradually been added over the years. I mean, for example, rules about ministerial treatment of gifts they receive was added quite some time ago. And then perhaps the most significant changes were following the Nolan Committee, the Committee on Standards in Public Life that was set up in 1995. And following their recommendations, the government accepted a number of changes. I mean, first of all, a new introduction, which refers to ministers being expected to maintain the highest standards of behaviour, and that's been carried forward, and equally accepting and putting prominently in the Ministerial Code the 7 principles of public life that Lord Nolan recommended. The other significant change perhaps was in 2007 when Gordon Brown became Prime Minister and published a paper on the governance of Britain. And one of the things that came out of that was the setting up of the role of independent advisor in terms that are by now familiar, that if there's an allegation and the Prime Minister, having consulted the Cabinet Secretary, feels it warrants further investigation, then he will refer the matter to the independent advisor. It's that investigations that seem to attract most of the attention, but inevitably most of the work never gets that far. Indeed, most of the work of the independent advisor is dealing with the declarations on ministers' interests. And the way that works is that ministers submit quite comprehensive form on all their external interests. And that is looked at by their permanent secretaries and by the propriety and ethics team in the Cabinet Office. And then each of the ministers' interests is cleared with the advisor. I mean, on the issues of conduct in the code, I mean, ministers want to comply with the code rather than ignoring it. And where potential issues arise, again, they consult their permanent secretaries. They may seek advice from the propriety and ethics team in the Cabinet Office, and occasionally the advisors consulted informally. I do think it's right to use this opportunity to have a further consideration of the role of the advisor, as the Committee on Standards in Public Life is doing. And I'm glad the government accepted most of the recommendations in Lord Evans' letter to the Prime Minister. What I think is the most significant of those is that the independent advisor can require his advice to be published in a timely manner. I never had issues about whether my advice was published, but sometimes there were quite long gaps between when I gave my advice and when actually something was published. The thing the Prime Minister didn't accept was the right of the advisor to initiate investigations. I mean, I think that's a mistake. One of the problems with the current system is that it does create a lack of confidence when the Prime Minister announces that he's cleared a minister without there being any investigation. In many, if not most cases, an independent advisor would come to the same conclusion. But I think it's more credible if that's done based on advice from the independent advisor rather than simply a statement from the Prime Minister. And of course, in many cases, there isn't a need for an investigation because ministers resign when they accept they've breached the code, or in some cases will be sacked. One thing, I don't think that breaches of the code should automatically lead to resignation. There are all sorts of relatively trivial ways in which the minister could breach the code. I mean, for example, giving public support for a bid for the lottery funding. But the other thing I think is there are issues about sanctions for the breach of the code short of resignation. I mean, one of which is something that Sir Christopher Geit, Lord Geit, the new advisor on ministers' interests, will be looking at. I mean, I don't think it would be possible, for example, for a minister to be suspended, as it can be the case for MPs who breach the parliamentary code. So there is an issue about what range of sanctions exists. I think I'll stop there, Robert, and be ready to answer questions afterwards.
Thank you very much. You've got admirably to time. So let's go straight now to Scotland and to our next speaker, Susan Deacon. Susan, over to you. Susan, you must unmute.
I've done that so few times actually in the last year. It would have to be today. So thanks very much indeed, Robert, for the opportunity to be here. And I'm really pleased that we are taking a little bit of time to compare and contrast in different parts of the UK. There's not enough of that in my view. So I'm going to, in the next few minutes, attempt to do a bit of a whistle-stop tour about the standards regime in Scotland. It pains me to say that I'm now into, I realise, my 4th decade of active interest and involvement in these matters. And I think it's only really possible to understand where Scotland is now in terms of ministerial standards to see it in a bit of a broader context. So I'm going to say something quickly about the wider standards regime in Scotland, a bit about the ministerial code here, obviously, and just share a few thoughts and opinions maybe for others to pick up on, should you so wish. So the standards regime in general is different here. We can have a great debate about whether it's better, but it's certainly different. And that goes right back to the early days of devolution, and much of the backdrop to devolution and the expectations that there were of how the Scottish Parliament and the then Scottish Executive, now as was Scottish Government as is, how it would operate. And a considerable amount of time in the early months and couple of years actually of devolution was actually spent putting in place the kind of infrastructure within which the institutions would operate. we may want to touch further on what some of that different landscape looks like, but I think I'm right in saying that actually the Advisory Committee on Business Appointments is really about the only body now that where the writ runs, if you like, to former ministers in Scotland as well as in other parts of the UK. Other arrangements for parliamentary standards were originally carried out through a Parliamentary Standards Commissioner. That's now been absorbed into a Commissioner for Ethical Standards and Public Life that covers national, local government and all NDPBs and the likes. So quite a different infrastructure. Now, if you take a quick look at the issues that have arisen over the last 20 years of devolution, you'll see relatively few financial controversies. There was the second First Minister stood down on the back of expenses issues, as did a leader of the Conservative Party, as did a leader of the Labour Party. But to be honest, over pretty small beer issues compared to some of what's come up in Westminster. You could say that's because the rules are stricter, and they are. You could say it's because there is a different self-imposed standard, if you like, that all politicians in Scotland have tried to adhere to from the outset. Or you could say it's because there's actually fewer members of the Scottish Parliament over the years who are, if you like, high net worth individuals or with a significant business background or connections, possibly all of the above. There have been a couple of ministerial resignations in the recent period, but they've been more to do with behaviour and allegations of inappropriate sexual behaviour in the main. So onto the Ministerial Code. And just as Alec did, I'll do just a quick canter through the history of this. The first code was discussed actually at the very first meeting of the very first Scottish Cabinet, which I had a privilege to be at. And was agreed in August 99. Since then, it's been revised on various occasions. In 2008, it was revised to include a prohibition on ministers from making misleading statements to Parliament. 2015 and 16 saw further changes around ministers being required to say whether they'd received legal advice, rules about parliamentary liaison officers, and the current code produced in 2018, as with the UK code, has new sections now on harassment, bullying and other such inappropriate behaviour. If you do a very, very quick compare and contrast between the two codes, as I've done, I mean, the first thing that would jump out at you is that the Scottish Ministerial Code, although based firmly on the core of what existed at a UK level in 99, and still to some extent, it's about half as long again as is the UK code, and that reflects the fact there's a lot more detail in it and a lot more specificity around a number of issues and how they should be handled. As with the UK arrangements, the FM, the First Minister, is the owner and the custodian of the code, which raises questions, as I know Alec has raised in other forums, about a kind of who guards the guards question about what happens when the First Minister is the person who's being complained about, as we've seen recently. And a similar arrangement is operated as at UK level in terms of there being independent advisors appointed by the First Minister who are brought in at her request to look into potential breaches of the code. And obviously the most recent attention, and I'm sure if participants are interested, this may be one of the Scottish issues that you may want to probe further. The most recent attention was obviously over the protracted and very considerable debate about issues that arose from the handling of sexual harassment complaints made against the former First Minister, Alex Salmond, and questions of whether the current First Minister, Nicola Sturgeon, had been in breach of the Ministerial Code. There was a parliamentary committee set up specially to look into this, which met for a year. It had 19 meetings involving witnesses, 22 others. The First Minister's evidence session alone lasted almost 8 hours and filled 82 pages of the Parliament's official report. In the event, the committee concluded that essentially it did feel, I don't think it was the exact words used, but it did feel that the First Minister had perhaps misled Parliament in the sense that her account of events, of what she knew and when, wasn't something that wholly convinced them. But they left it to the independent advisor, James Hamilton, the former Director of Public Prosecutions in the Republic of Ireland, to say in his report whether or not she was in breach of the Ministerial Code, and he in fact found that she was not. In the interim, however, there was a no confidence vote and various well, I would go so far as to say actually the Ministerial Code was almost weaponised in the political debate in terms of opposition parties calling for a resignation, the Scottish Conservatives in particular. So that's a quick canter through where we are. Lots more that we could potentially discuss. Suffice to say that the Salmon Inquiry shone a spotlight on a whole range of issues which are relevant to this discussion, but also go wider about the powers of the Parliament over the executive, about the role of the Permanent Secretary, about the independence of parliamentary committees, work of special advisors, and so on. It just got its work under the wire before we went into the pre-election period, so it remains to be seen how much will be taken forward in terms of the work of that committee and some of the issues that it threw up. Just to conclude my own thoughts, one, I think we should discuss these issues a lot more and in a way where there's a bit more light and a bit less heat around the debate. Secondly, I think we should be realistic about the limitations of rules, and that no matter how good and effective they are, or indeed those who advise on them. And I suppose I always come back, and again, Alec mentioned the Nolan principles or the 7 principles of public life. I always come back to those 7 principles that I think are just a tremendous framework within which anyone in public life should operate. And they have stood the test of time and been adopted by governments, parliaments, public bodies right across the UK. And I think we should do more to really discuss, question and test whether those who hold public office are upholding those 7 principles, because at the end of the day, that's what really matters. I hope I've not gone too much over time. I hope I've covered a reasonable amount of ground there, and obviously happy to answer questions.
Susan, that was great. I can't resist saying the 7 principles of public life were composed by a professor everyone will know, sadly missed, Tony King, in the back of a taxi when he was one of the original members of the Committee on Standards in Public Life. And they really have stood the test very well. Richard, over to you to talk about the Advisory Committee on Business Appointments.
Well, thank you very much, Robert. As people probably are aware, ACOBA is primarily concerned with the behaviour of ex-ministers. It advises on individual cases where an ex-minister or indeed an ex-senior civil servant wants a new job after leaving office. The committee has 2 sets of rules which the committee applies, one for ministers and one for civil and crown servants. The rules are broadly similar, only differences of detail. They apply for the 2 years from the date the person normally leaves office. There's rather a mixture of aims in the rules. They're there to maintain propriety, especially to avoid improper use of official information, to avoid conflicts of interest, to avoid suggestions of reward for decisions taken whilst in office. At the same time, there's a recognition that interchange between public and private sectors can be healthy with sufficient safeguards, and there's a wish not to deter good people from entering public life. So those factors are behind the 2 sets of rules. The committee has 3 political nominees. Our chairman is Lord Eric Pickles, 6 independents, including myself, appointed by the Prime Minister, and a 4-person secretariat. The ex-minister or ex-official has to make a fairly detailed application for each individual job. The committee of the secretariat then seeks input, factual and advice from the relevant department, fairly full piece of input there from the former department, looks at the nature of the proposed job. Then the secretariat carries out a fairly detailed risk assessment and puts the package to the committee. We get about currently between 6 and 7 cases a week. It's roughly 50-50 ministers and civil servants. There are really, in simple terms, 3 ways each case can go. A green light will be given to the very straightforward cases where very standard and fairly minimal restrictions are put in place, especially for unpaid roles or where there's no connection whatsoever with the previous job, or in the academic or voluntary sectors, a more relaxed view is taken there. A red light is rare but has been applied where in effect the individual is told there has to be a 2-year wait, in other words that the position is unsuitable. And the third and by far the largest category are the amber lights. Typically a waiting period is advised. Could be 3 months, 6 months, 12 months, it depends on each case. Restrictions may include, for example, no lobbying of government, no use of privileged information, and no involvement in bids for contracts or for funding. In the case of ministers, the advice goes directly to the minister, and it is published when the person takes up the new job. And one important feature mentioned here is that when it's a red light case, when they're advised that they should not take the job, by definition, the letter is not published, assuming they don't take the job, because there's no job to advise on, as it were. So those are not seen, but the green and the amber light cases are placed on the website, and everybody can, indeed the media and others do watch them. Just very briefly, a word or two about strengths and weaknesses of the system. First of all, I mean, obviously it's not backed by any sort of statutory powers, but it seems to work. As far as we're aware, we don't know for sure, but it seems to be very, very few breaches of the rules, either people not applying in the first place or applying too late or breaking the restrictions which are imposed. No scandals as such, no big concerns have arisen in recent years. There have been 1 or 2 cases we can come back to where people have taken on questionable jobs after the 2-year period, but within the 2 years, it seems to work. We see the approach towards transparency as being extremely important and being a powerful constraint on behaviour. We publish, as I mentioned, the job and the conditions which are being posed and the waiting period. If there are any breaches or improprieties where they've not followed the rules, that's also published. And I suppose we would say that what we call sometimes the court of public opinion is quite powerful in this area. But there are weaknesses. It does depend upon what I might call honourable behaviour. The most common criticism is that the committee has no formal sanctions. The main sanction is to name and shame and to publish, and nor does the committee have any investigatory powers or resources. And perhaps later on, Robert, we can discuss what possible changes might be made. There's no great appetite for a statutory regime, and there are pluses and minuses of going down that road. But I'll stop there and hope I've just given a broad oversight of how ACOBA works.
Well, thank you, Richard, and thank you to the other speakers. We're going to have a panel discussion now for 20 or 30 minutes, and then we'll come to Q&A from the audience. So please keep your questions coming in for when we turn to you. But let me put my first question back to Richard about enforcement, the point at which, Richard, you left off. If ACOBA were to have enforcement powers, let me ask you as a lawyer, what form could they take? It's not quite like a non-compete clause in relation to private sector employment, where the courts can issue injunctions or award damages. Could you envisage anything similar? Have you had a discussion, if you did have enforcement powers, what shape they could take?
It's a very good question you put, Robert, and I think you're quite right to say that if there were to be mandatory sanctions of one sort, or sanctions with a sort of a binding effect, that would inevitably, I think, involve statutory intervention. And I think there's a feeling that it would be pretty heavy-handed to involve the criminal law if, for example, one wants to impose fines. I mean, fines can be imposed for breaches of electoral law, but that is controversial in its own way. I think there's also a feeling it's very difficult to devise what the law would look like. I mean, the situations are so varied, the circumstances do call for fairly fine judgment, and to imagine that being done within a statutory regime where inevitably one looks very closely at the precise wording of the statute, lawyers will be involved on both sides. And I think really the question will be, well, what is the mischief which we're trying to stop? If there was widespread abuse and widespread examples of people engaging in unsavory or unacceptable behaviour, then maybe the law should intervene. One question which has been at least discussed is whether contracts could include some sort of obligation to abide by the rules after employment. And then you get into the areas like restraint of trade, which employment lawyers are concerned with. I think it would be easier to do that for civil servants and crown servants who have contracts. I may be corrected on this, but I don't think any minister has a contract as such. It's an appointment, it's not a contract. And it'd be quite interesting to see how you'd have a sort of a contractual sanction applied in the case of a minister. So I think the present feeling is that we could and probably should do more to make use of the sanctions of publicity. We've moved quite considerably in the direction of greater transparency in the last few years. And I think it's fair to say that the criticisms of toothlessness, which have appeared from time to time in Private Eye and elsewhere, have been rather reduced in recent years because people can see exactly what's going on.
Thank you. My next question is going to be to all of you, and it's about the fragmentation in this area and the overlapping jurisdiction of the different watchdogs. So Susan told us how in Scotland they started off with a parliamentary commissioner for standards, but you've now got someone, as I understand it, with a wider jurisdiction, the Commissioner on Ethical Standards in Public Life. At Westminster, we still have a lot of different watchdogs, and just to illustrate the point, the so-called cash for curtains scandal is currently being investigated, I think, by no less than 3 people, by the Parliamentary Commissioner for Standards, because Johnson has been complained about in his capacity as an MP. It's also being investigated by the Electoral Commission, because there may have been a breach by the Conservative Party in relation to party funding and donations. And I think Alex Allan's successor, Christopher Geit, is also investigating it as the independent advisor. And on our blog a couple of months ago, Professor Rodney Brazier suggested that we need a new overarching Ethics in Government Act, suggesting, I think, that some consolidation would be a good thing. So, Susan, it sounds as though you have consolidated a bit in Scotland. Could you tell us first about the effects there, and then I'll come, if I may, to Alex.
I think, well, I think first of all, there's nothing wrong with each of the 4 nations, if you like. You can debate England/UK, but in the UK Parliament and so on. But I think it's quite right that there is a different landscape because so many other aspects of the political culture and practice is different. But I do think there's something missing that is some UK-wide oversight of, if you like, or certainly comparison of experiences and practices. I'm not sure that we are as unfragmented here as maybe you suggest. I think, yes, there's been an element of consolidation around certain bodies, but there's been a lot of noise generated by lots of, there's been a heavy reliance in Scotland, and a conscious one, of the Parliament itself really having a lot of oversight of these matters. But that, as I said earlier, often generates more heat than light. My own conclusion in this, as in many other areas, and funnily enough, I also argued this when I stood down from my role as chair of the Scottish Police Authority overseeing our National Police Service, is that more scrutiny does not necessarily mean better scrutiny, and often less is more. And I think if we could apply that, have a self-denying ordinance, if you like, both those within our political institutions, but also those who take an interest in it and comment upon it, to try and have more focused, time-limited, clear oversight of these issues, that would be enormously helpful. But it's definitely an issue, and having watched the cash for curtains issue and the sort of exponential growth of different inquiries around that, then yeah, it's a very, very good example of why more does not necessarily mean better scrutiny.
And by more scrutiny, did you simply mean the fragmentation, or do you mean the sort of cumbersome, rather box-ticking approach that some of these watchdogs can sometimes morph into?
I think both. I mean, if you think about what is the aim here, it's to uphold standards and critically to build public trust. And that requires there to be an element of accessibility to these processes. And yes, it's important to do the job properly, but frankly, the more words that are generated and the longer that any report or inquiry is, then the more it just creates a fog of war, if you like. And I think there is something about how you ensure that the public is able to see, if you like, the 1/9 of that iceberg and the really key issues and insights that would be of particular interest to them. And I don't think we've mastered that either.
I think, if we may, we'll come on to the public a bit more in a moment. But let me come to Alex about fragmentation.
Well, one of the things it's quite often argued, or has been in the past, that the Parliamentary Commissioner for Standards and the Advisor on Ministers' Interests should be merged, and that would create sort of the independence and the right of initiation and so on. I mean, I don't think that's the right approach, because there would be an issue of accountability, which is a problem, because inevitably the Prime Minister has to be responsible for who is in his or her government, and has the right to determine that. And I think it's right that there is an advisor who reports to the Prime Minister on that, whereas the Parliamentary Commissioner reports to the House of Commons, and it reports to the Standards Committee, who report to the House of Commons. And so I do think that if you merge the two, there would be an issue of accountability. And they, and indeed the Electoral Commission in the example you give, are looking at slightly different aspects. I mean, the Electoral Commission, as I understand it, is not investigating the Prime Minister as such. It's investigating the issue of whether the Conservative Party declared the donations to it. So there are a range of different issues which are being examined. So I mean, I accept that there's fragmentation. I'm not sure that simply merging different streams is really the way to go.
And Alex, while we have you, can I come to one of the questions that Susan raised about the awkwardness for the independent advisor when you're asked to investigate an alleged breach by the Prime Minister himself or herself? Was that something you ever encountered during your 9 years in office?
No, it wasn't. I never had any issues where the question might be investigating the Prime Minister. Obviously, the current case, the issue does, although as I understand it, it's a question of whether the Prime Minister's declarations in his interests as such. And I believe it's the Cabinet Office investigating, and then the independent advisor will advise on some of the issues. So I think that there are potential issues, but I mean, I know in Scotland, I mean, the First Minister referred herself to the independent advisor, and so that wasn't a problem. And one of the things that I notice is different in Scotland is that there's more than one independent advisor. And so I'm not quite sure, presumably the First Minister chooses which advisor does the investigation. I don't know, Susan, if you want to comment on that.
So, Susan, would you like to come in on this?
Yes, Alan's quite right. There's more than one advisor, and I think that's probably a good thing. The other current advisor is the former Lord Advocate Eilish Angelini, who, in the case of the Alex Salmon inquiry, to shorthand it, ruled herself out of doing that because she was doing another piece of work that she felt conflicted with it, and it was therefore James Hamilton that undertook it. But there have been several others who have served as advisors. In fact, the initial two advisors were the first two presiding officers of the Scottish Parliament, David Steele and George Reid. Although interestingly, David Steele in fact resigned over a point of principle from that role back in the day. So, but I think there is something to be said for there being multiple advisors.
Interesting. Richard, anything you want to add on fragmentation?
First thing I can do, I think, is just read the paragraph from the submission made by our chairman, Lord Pickles, to the review of the standards landscape being carried out right now by the Committee on Standards in Public Life. And his letter says, the landscape is muddled and it cannot be clear to most outsiders who is responsible for what and who is accountable to whom. Within the business appointment system, there are overlapping areas of standards where COBA has no role and remit, where other independent bodies are responsible, which is often misunderstood. And he goes on to explain that many ex-ministers may either stay in the House of Commons or the House of Lords, or may be appointed to the Lords, and they're arranged, as you've mentioned, if other people are concerned with outside appointments. But I stress that a COBA is only concerned inside the 2-year period after they've left ministerial office. So I think there is muddle. We've not put forward any proposals for rationalisation, but I'm not sure, how serious the problems are vis-a-vis business appointments compared to other areas. But undoubtedly, there is some muddle and confusion out there.
It may be that the Committee on Standards in Public Life considers all this as part of their current review. I think they're due to report in about September. Alex, can you tell us any more about that?
I don't know. I mean, I'm not sure that they've fixed a particular timetable. There's one interesting case on the interaction between ACOBA and the Ministerial Code, which was David Blunkett's in 2005 or 6. I can't. No, sorry, it must have been sometime like that, where he resigned as a minister following issues about when he was Home Secretary and facilitating residence for his lover's nanny, I think it was. But then, so he resigned as a minister. While he wasn't a minister, he actually took up a job without informing ACOBA and was then appointed after the next election as a minister. And I think he was Secretary of State for Work and Pensions. And then when his failure to alert ACOBA came to light, he then resigned as a minister. So I mean that was a case where there was sort of interaction between the Ministerial Code and ACOBA.
Well, one thing we do in all our letters where these matters are relevant, we always draw the attention of the individual to the relevant rules in the Commons or the Lords as appropriate. So there is some sort of dovetailing done in each individual case, but you can end up with sort of two judgments being made at the same time.
Now, we'll come to the audience in a moment, and please keep your questions coming in. But let me have one more with the panel, and it's about the question of public trust. Susan mentioned this, the importance of transparency and accountability to try to maintain public trust in all these different public office holders. And sometimes I've wondered whether there isn't a paradox that occasionally watchdogs may actually serve, not deliberately, to diminish public trust, because that part of their task is to expose instances of bad behavior. And it tends to be only the instances of bad behavior that then get widely publicized in the media. And that leads to the very common impression on certainly some parts of the public that they're all in it for themselves, they're on the take, and the kind of things that get said in loose talk about politicians and now about public officials. Who wants to go first on this? Richard, you may have felt this a little bit when you were Information Commissioner as well.
Well, it's a familiar issue that, when you expose anything which doesn't look quite right, people will say that confirms their prejudices or their suspicions. But I think I would say that keeping those sorts of things secret can often be worse. I mean, perhaps the BBC right now might reflect that the cover-up has been as bad as the original sin. So I don't really buy very strongly into that particular argument. In the case of ACOBA, as I've said, we've moved very considerably in the direction of transparency, and I think it has made a really quite significant difference to both the reputation of the system and to the way in which each individual case has been handled. I mentioned the frustration that where a job is completely vetoed, there is no transparency, and I can't see any easy way around that. We weren't shy, it was about 3 years ago when Boris Johnson stood down as Foreign Secretary and took up a job almost straight away with the Telegraph, going back to being a writer on the Telegraph, and he didn't come to the committee. And we published our letter to him, which included the phrase that the conduct was unacceptable. That was a fairly rare example of somebody who didn't apply in good time, who took the job, and there's only been a handful of such cases, so we're not shy to spell out the situation. But I think keeping quiet in those cases is very rarely going to be beneficial.
ACOBA, I think, is not the only watchdog that has rebuked Boris Johnson. He's also run into trouble with the Parliamentary Commissioner for Standards on repeated occasions. Alex, do you want to say anything about public trust?
Well, I'm not sure I really agree with the thesis, because, I mean, it doesn't seem to me that, for example, on the Minister's interests Ministerial Code, whether or not there's an investigation, there's still a lot of publicity. And the issues you raise are out there. People raise concerns, and it may diminish trust, but that's about the publicity, and there doesn't seem any less or more publicity depending whether or not there's an investigation. And as I said in my introductory remarks, to some extent, I think that it could increase the confidence in the system if the independent advisor had a right to initiate investigations. Because at the moment, as I said, when the Prime Minister simply dismisses an allegation and said, this is fine, there's no breach of the code, that in itself can generate adverse publicity. Whereas if the independent advisor had investigated and said that in his opinion, there wasn't a breach of the code, in some ways that would reduce the concerns that are raised. And so I think it would give more credibility to the system.
I think one of the arguments put by the Prime Minister when rejecting that was the risk of tit-for-tat allegations, often brought for partisan reasons. Did you experience any of that when you were in post?
Well, no, and I think the experience of the Parliamentary Commissioner is interesting here, because she has the right to initiate investigations. And in her annual report, she lists the number of cases put to her to investigate, and the number she actually did investigate, where, it's a tiny fraction of the total number. So, I mean, I think that were the independent advisor to have a right to initiate, he, as it happens, would need to be robust in simply saying, no, there's nothing to investigate here. And okay, that might certainly in the early days be a bit controversial, but I think it's perfectly operational.
Yes, and I think there are occasions when the Parliamentary Commissioner receives quite a lot of tit-for-tat allegations. Susan, let's come to you last on public trust.
So I think the paradox that you articulated, Robert, is real. I think it's very sad, actually, as lots of evidence and research bears out, there is a sense in which the public tend to say, well, we expect that of them. So their expectations aren't particularly high. So there's certainly not a reason to not have good reporting and regulation and so on of standards. But I think there's two other points that I just throw into the mix rather than repeat what Allan and Richard have already covered. One is, I think we have to realise that this sits within a much wider 21st century challenge around transparency and what it means. And if I may almost channel Prince William, I guess, in his comments that he made with regards to the recent BBC issues. You know, he spoke about the importance, I paraphrase, you know, in an era of fake news, that there are sources, you know, through which you can look for reliable information. And I would add to that, to some extent, also a distillation and clarity of information. So I think there's an inherent tension at the moment that rightly more transparency is wanted. More of it almost naturally exists through the communication channels and technology that we have. But that makes the paradox that you've identified even more important to address, which is how you communicate the facts to the public. And then the second point is just to say, the other fascinating thing, of course, is the basis upon which the public actually make up their minds. As we saw in the recent elections, despite Keir Starmer's best efforts, very little mud appeared to stick to Boris, the Conservatives, in that election. And similarly, you know, in Scotland, even at the height of the controversy around the various issues affecting Nicola Sturgeon and the Scottish Government, apart from a bit of a blip along the way, a minor blip, really her stock and the stock of her party remained very, very high. So the public clearly reached their own conclusions based on a range of different, not just thoughts, I think, but also more gut feelings as to how they judge their leaders and what they want from them.
Yes, and how much the public care may well be something that comes up now in questions. Let's go now to questions. Sorry, everyone, to keep you waiting. Lisa, could you give us the first round?
Yes, and thank you everyone for your questions. Do keep them coming in. So we're going to go first to Tim Durrant and then to Michael Torrance. And the last question is an anonymous one, picking up on what Susan said about transparency, which I will read out. But to Tim first.
Hi everyone, and thank you for having me. I hadn't realised I was going to be called on to ask my question with my own voice. It's very exciting. I wanted to ask about the legal status of the various sets of rules. So as I understand it, and sorry, I should say I work at the Institute for Government on this stuff, so very interested in this. The Ministerial Code does not have a legal basis. The business rules, business appointment rules, don't have a statutory basis. Does the panel think that that should change? And if so, sort of how? Because if you look at, for example, the Civil Service Code at the UK level and the Special Advisors Code at UK level, they are both, the Prime Minister is required to establish those codes, but not specifically say what's in them. Whereas in Northern Ireland, there is a requirement to have both a ministerial code and there is a legal requirement for certain aspects of that ministerial code. So yeah, do the panel think they should have these rules, these codes should have legal bases, and how far would they go in defining those in law, if so?
Thank you, Tim. I'm trying to write a chapter just at the moment about this. So you and I must be in touch with each other, and I'll be really interested in the panel's answers to your question. But let's go straight to the second question.
Mm-hmm. So I think we have lost our second questioner, possibly some tech issue, so I'll read it out. The Lords Constitution Committee is conducting an inquiry into updating the UK Cabinet Manual. The Scottish Government issues a Scottish Ministerial Code. Would it also be helpful for the Scottish Government to issue a Scottish Cabinet Manual to clarify the operation of government, including relationships with Parliament and the courts north of the border?
Very good. That's clearly one for Susan.
Indeed.
And Lizzie, I think you were going to read out the third question as well.
Yep, so the third question, as I said, picks up on one of the points that Susan was making about transparency. An anonymous attendee has written in to say that they're interested in the panelists' views on the extent to which transparency builds or maintains trust amongst the public that ministers are complying with expected standards? Do you think transparency is sufficient to build public trust? And if it's not sufficient alone, then what else might we need?
Very good, thank you. Alex, can we come first to you about the legal status of the rules? Does it make a difference whether the code is statutory or non-statutory?
I'm not sure how much difference it makes. I mean, I could see if there was a provision that the Prime Minister had to issue a ministerial code. Well, I mean, he does anyway, or she does anyway. And so I'm not sure how much difference that would make. And I mean, the sorts of things that I could imagine being required to be in ministerial code are the sorts of things that are in there anyway. I mean, I may be not thinking fully enough, but I can't imagine what provisions there might be that were required to be in a ministerial code. So, and I do think that ultimately the Prime Minister has to be responsible for who's in his government, has to be able to decide that. So, I mean, I feel that a statutory ministerial code that in some ways was legally enforceable would actually, I think, would restrict the Prime Minister's ability to do that, which I don't think is the right way to go.
Richard, ACOBA, you're non-statutory. What difference would it make if you were statutory?
Well, there's no official position on this, Robert, within the committee. I've mentioned earlier that, you know, we see the case for stronger sanctions, but there's a paradox that without statutory foundation, the sanctions can't be very much stronger. I mentioned the possibility of contracts being used. We are, as I've said, you know, not only going down the road of transparency. For example, now there's an engagement with the vetting system for public honours. So if someone is nominated for an honour, then there's a look at what's happened under the ACOBA umbrella. Also, we're giving consideration to whether people, you know, could be not disqualified, but at least inhibited from future public office if they breach the ACOBA rules. But I said earlier, it's not easy to envisage what statute would look like in this area. The criminal law, I think, would be somewhat heavy-handed. I think it's always very, very difficult to put ethical considerations into a statutory framework to find the right language and the right concerns. There are already some relevant statutes. I mean, the Official Secrets Act does apply to any ex-minister. I mean, that's very rarely used in practice, but it's there perhaps inter aurem. So I think the jury's out at the moment on this one. You know, we're not complacent. I think the reality is there's no real appetite within government for a statutory approach at the moment. And I repeat what I said earlier, fundamentally, I think one wants to be clear the nature and the extent of the problems to justify statutory intervention. I think there's still, you know, mileage to be obtained within the existing system, but that's not to say we've ruled out some sort of statutory intervention for all or part of the system.
Thank you. Susan, can we come to you? And can we ask you, first, does Scotland need a cabinet manual, which was one of the questions, but could you also try and answer the third question about transparency is necessary to build trust, but is it sufficient?
Okay, so if I touch on the cabinet manual question first, I have a confession to make here. I mean, many people spent lockdown watching Netflix. I watched an unhealthy amount of parliamentary proceedings, one of which, fortuitously for this discussion, was a select committee session with Mark Sedwill and Gus O'Donnell on the revision of the current cabinet manual, which got me to having a look at it and thinking about precisely the question that was asked. And I think they both cautioned the MPs that were questioning them about, my words not theirs, but the potential of over-engineering the cabinet manual and trying to be overly prescriptive and cover everything, when in fact really it would just provide a framework within which to operate. So I would veer away from something exactly similar here. However, what I would point out is that again, within that context, there's a different landscape. There's many, many other framework documents and practices which put flesh on the bones, if you like, of how ministers should interact with Parliament. And in fact, it's one of the areas where the Scottish Ministerial Code is much more detailed than is the case with the UK Ministerial Code. So my view would be you don't need a separate manual. There's probably enough set out there. And I know you asked me to come to the third question, but if I can touch on what I think was the first question, which is about what you put in statute. Again, in Scotland, there has been, in that wider landscape, more things put into statute. I actually chaired the committee which considered the interest of members of the Scottish Parliament bill, which came onto the statute book back in 2006. And I remember arguing quite strongly and successfully on that occasion to not place more and more requirements, not just on MSPs, but on their families and others, because there was a kind of default towards putting more and more into that. I argued much less successfully when called to give evidence to the Parliament Standards Committee when it was considering the proposed Lobbying Act, that shouldn't be put into statute, and in fact it was in 2016. So there's quite a significant statutory framework now for lobbying in Scotland that's really quite different from the UK. And in fact, the Parliament's Public Audit Committee, as part of its post-legislative scrutiny, have published a very interesting report on that just in the last couple of months on how it's operated in the first few years. And I would say the jury's out about how effective it's been. On the issue of transparency, and having spoken for quite a long time, I think I'll keep my comments very brief. I do think there is a whole other discussion to be had, and it's a hugely important discussion about that question that I posed earlier, about how you marry together far more visibility and transparency on politics with the whole question of public trust. And I'm inclined to say I don't think we're at first base in some respects in the UK, or possibly elsewhere in the world, of how we square that circle. But during the course of the rest of the 21st century, we'll have to.
Let's go to our next. Yes,
Can I just quickly come in on the Cabinet Manual? Because I do actually think it's a valuable document. I have to say, of course, I'm slightly interested. I was involved with Gus O'Donnell in drawing it up in 2012. But I think it's got a lot of useful information in. And I mean, it had some issues around, for example, the appointment of a Prime Minister, and quite a lot of novel stuff in there. So I do actually think it's a valuable document.
Very good. Let's go straight to our next round. Lisa, what have you got for us?
So we're going to go first to unlock democracy. Our second question will be from Stephen Gosling. And Stephen, I know you've submitted a couple of questions. Could I ask you to pose your first question about legal and political constitutions? And then we'll finish up with another anonymous one.
Thank you.
So we'll unlock democracy first. Yes, so it's Tom Brake, and the question is about the Ministerial Code. And that is, do the panelists understand civil society's concerns that we have a ministerial code that our present Prime Minister is not willing to enforce and is unlikely to be willing to enforce against himself, for instance, for breaches of 7.20 in terms of accepting gifts? And is the Ministerial Code something that can be reformed, or is it in effect dead?
Thank you. Hold that panel if you would, that question about enforcement. And let's go to the second one.
Thank you, Steve Gosling here. Isn't the only way to make these standards or any rules of the governance of government unambiguously stick to have legal written rather than a political constitution?
Very good. Nice and pithy. And can we have the third question?
Yep, so the third question comes from one of our anonymous attendees, who writes that overwhelmingly ministers are also members of either the Commons or the Lords. With that in mind, would it not be simplest to do away with a separate regime and use the standards commissioners, not appointed by the PM, might be seen as more independent, and the committees of the two houses, perhaps with sanctions also subject to the agreement of the relevant house? So a question about combining standards regimes which exist.
Yes, which we partly discussed, but we can come back to. I think, Alex, Tom Brake's question is squarely for you about enforcement of the Ministerial Code. And would you like to deal with the third question as well? And then I'll come to Richard.
Yes, well, I do think, as I've been saying, that the Prime Minister ultimately has to be the person who decides who is or isn't in his government, and you know, in some ways he has to be held accountable to that, to Parliament, and indeed to the electorate ultimately. I think the advisor is there who can provide, as it's implied, advice to the Prime Minister on whether or not there has been a breach of the Ministerial Code. And I mean, there are clearly issues about, I mean, I do believe ultimately that the Prime Minister has to be a judge of whether there's a breach of the Ministerial Code. But I mean, as was the case in my resignation, I mean, I gave advice that there had been a breach of the Ministerial Code, which the Prime Minister didn't accept, and so I felt I had to resign. As I say, I don't think the Ministerial Code is a redundant document. I think it's still quite an important document. And sorry, what was the third question that you put to me? Oh, that was something I did address earlier about the combining the roles of the Parliamentary Standards Commissioner and the Independent Advisor. I don't think that's the right way forward, as I said, because of issues of accountability, that the advisor has to be accountable to the Prime Minister, the Parliamentary Commissioner is accountable to the Committee on Standards in the House of Commons.
Richard, would you like to answer the question about the legal and political constitution?
Well, we've been over some of this ground already. I'm a lawyer, as you said earlier, Robert. Way back in 1984, I wrote a sort of a pamphlet in which I was fairly skeptical of self-regulation. I'm not a great advocate of self-regulation, although there's a spectrum of different possibilities. I certainly agree with, I think it was Stephen who raised this point, Steve who raised this point. If there was widespread evidence of abuse, if there was clear examples of people who were exploiting their time in office and if not engaging in actual corruption, were certainly behaving in ways which are unacceptable, then there would be a more powerful case for legal intervention. But I'm a little skeptical in this area, speaking personally. Once you put it on the statute, it gets very rigid, it gets very precise, it gets very legalistic. I think also we've got to recognize that both for officials and for ministers, perhaps the traditional approach was that you spent your entire life in the public sector and you retired at 60, 65 and maybe then did something sort of part-time in your retirement. But increasingly, both in the political arena and in the official arena now, we've got far more interchange between public and private sectors. And I think, as I said, with safeguards, that is not a bad thing. We've, if you like, torn down the Berlin Wall between the two sectors. People don't go into one sector for their entire career. So I think you've got to have some flexibility and to permit movement in and out subject to safeguards. And I think if you start putting everything in our area in post employment or post ministerial office regimes, what you do then, if you set it out in great detail in a law, I think we'd get ourselves very quickly tied up in knots. There are so many, I mean, just speaking for the half dozen or more cases we're dealing with every week, there are so many different fact situations. I find it very hard indeed to get my head around what a law might look like in this area and what precisely will be the abuses. I mean, even lobbying, you know, we're hostile to lobbying. It's not easy to actually define what lobbying is for the purpose of a law. We've got the Register of Lobbyists, and that is, I'm not sure working terribly well at the moment. I was interested, Susan mentioned, I think there is more of a prohibition on lobbying in the Scottish law than there is south of the border. But I could envisage perhaps specific prohibitions, using official information, avoiding lobbying, but to have a sort of control system over all post office appointments, I'm still finding quite hard to see how it works in practice.
Susan, we're going to come to you for the last word. And would you like to enlarge a little bit on what your own reservations were about the Scottish law on lobbying and putting too much into legislation?
Well, two things. One, precisely the point that Richard made, which is that legislation by definition needs to be precise, and you do get tied in knots in trying to define everything. And the main statutory provision that's contained in that Act, incidentally, is a statutory register. And that's the thing that has, as I said just recently, been looked at a few years on, and predictably, I would say, is riven with debate and discussion, and even an occasional dispute about what should and shouldn't be included in that. And at the end of the day, I'm not sure that that's done a whole heck of a lot to really improve practice. The second concern, though, and again, I was interested that this came out in the Parliament's Audit Committee report on the subject, is that it can act as a disincentive to engagement. I mean, one of the things that the Scottish Parliament in particular absolutely put up in lights from day one was to be an open Parliament, and the whole, physically even the way that the building is designed is all to encourage people to interact with their decision makers. And actually, the regime that's now in place, I would argue, and I did argue before it was put in place, you know, can act as a disincentive to engagement, because and actually some of the big, more powerful and wealthier interests can always find a way to gain access, should they so choose. And in fact, you're maybe having an unintended consequence of those that you know, can't afford to find ways around the system, just are put off by it. The final point that I would, if I may, just in response to the questions that have been raised, is I just want to emphasise that I do think it's important, and Alec touched on this as well, that whichever form it takes, ministerial codes, advisors, cabinet manuals, whatever, that I think being a minister is fundamentally different from being a parliamentarian. And I think there has to be something that absolutely recognises the particular issues and potential pitfalls, actually, that every minister can face. So I wouldn't just completely conflate the two, but I do think that we have to remember that ministers are also required to follow whatever standards are put in place for their parliament. And the absolute final thing that I just wanted to say, in case we run out of time to say it, although there haven't been some of the same issues around financial impropriety and so on, or alleged financial impropriety in Scotland, I do think there are other issues which absolutely have not been caught. But, and this is a personal opinion now, and I should have stressed earlier, I have not been involved in party politics or any political party now for 13 years, more in fact. That I think the thing that bedevils us in Scotland is a kind of coziness, and some would say more pejoratively a kind of cronyism almost, partly by dint of being a small country. And I don't think we've begun to really shine a light on some of the actual interactions that take place beneath the waterline that are hugely influential and actually lead to a lot of bodies being, in my opinion, too close to government and government too close to them. And that, for me, would be the next chapter in Scotland's journey that we really need to think about more.
Well, it sounds as though that's a topic for another seminar. I'm afraid we must now wrap this up, with apologies to all those whose questions we couldn't reach. Thank you to all three of my speakers for a really interesting, very thoughtful discussion. Thank you, all of you in the audience, for attending. This event was recorded and it'll be posted online on the Constitution Unit website and on our YouTube channel and on the Constitution Unit podcast after the event. And we'll let you know when the recording's available and hope you might want to share it with others. Our next event is a 2-day conference, 2 half days, on the mornings of the 17th and 18th of June on the Johnson government's constitutional reform programme, with a stellar lineup of speakers, starting with the Lord Chancellor Robert Buckland giving the keynote. Details of that are on our website under events, as are details of how to join our mailing list, and please encourage others to do so. So we hope to see you at the conference next month. In the meantime, thank you, all of you. Special thanks to our speakers. Thank you and goodbye.